Yes, good morning to everybody, to the students of the Advanced Private International Law. And this is the series 3 on the conflict of laws. And the last one, but goes with a certain repetition also. So let us continue to without wasting the time, because as I told you, the students are would have been present over there. Naturally, it will be quite good idea so that they would have to participate it, and I would have to ask the questions to them, and they are still supposed to give the reply. And if they don't give the reply, that I will come to the rescue. So traditionally, civil law and common law countries have followed different approaches in determining which court has jurisdiction in a civil action when the parties have not agreed on or submitted to the forum. In civil law countries, start from the premise that there is one principal place where the suit can be filed. The domicile of an individual or the seat of a legal person, such a corporation, general jurisdiction. In addition to these general basis of jurisdiction, a suit ordinarily may be brought in the court of the place to which the suit has a special connection. Exemplification, e.g., where a tort was committed, or where effects were felt, where the alleged breach of contract occurred, or if the title of real property is involved, where the property is located. Within parentheses, specific jurisdiction. Increasingly, countries have limited the exercise of jurisdiction and have prohibited parties from varying these limitations by the agreement. For the protection of the weaker parties, such as employees and consumers, such pattern has emerged. For example, in the procedure law of the EU, it was clearly mentioned. So now let us go to the courts in the common law countries, particularly in the United States, also asserts jurisdiction on this basis, but additionally will exercise jurisdiction simply on the basis of the physical power over the persons of the defendant. Thus, a court in the United States has a jurisdiction over a defendant if he has been served with the documents commencing the suit in the territory of the state in which the court is located, even if he was there only temporarily or while in transit. That is called the transient jurisdiction. The United Kingdom and Ireland also exercise jurisdiction on this basis. US law also provides for the jurisdiction over a company when it has been connected in some ongoing way with the state, even if the particular dispute does not arise out of that connection. Thus, a court is authorized to assert a jurisdiction when the defendant is doing systematic and continuous business within its state, even if the dispute arose elsewhere. Yes, I would have to ask the students if they are participating in my virtual class, but I tried my level best to contact them, but not a single person I could have to get their WhatsApp number. But still, I will try my level best so that it should not be an absentia class. It should be the virtual class with the students participating in it. Now let us resume. Most countries provide some basis of jurisdiction for the benefit of the local plaintiffs. French law, for example, grants a jurisdiction if the plaintiff possesses a French nationality. And German statutory law permits a local plaintiff to sue an absent defendant on the basis of any property any property, yes, of local grants of jurisdiction if the plaintiff possesses French, for instance, French nationality is a German statutory law permits a local plaintiff to sue an absent defendant on the basis of any property of the defendant, maybe in Germany. Let us see in any other way. Through the modern German court decisions have given the provision a more limited reach. Rules such as these, which favor plaintiffs' transient jurisdiction, also falls into the category, are known as exorbitant rules of jurisdiction. I repeat, the rules such as those which are favor plaintiff transient jurisdiction also falls into the category, also known as exorbitant rules of jurisdiction. Within the EU, they have been abrogated in cases in which the defendant is habitually residents within the EU. However, EU member states may retain exorbitant jurisdictional basis on the national law in cases involved non-EU defendants. Internationally, beyond EU, these rules as well as the American doing as well as American doing business Yes, I beg your pardon. Yes, beyond the EU, these rules, as well as the American doing business jurisdiction rule, are a source of considerable tension. The Hague Conference on the Private International Law sought to formulate an international conventions on the jurisdiction and judgment recognition. The effect was abandoned when the difference proved to be a lost bridge. Instead, a much more limited conventions on choice of the court agreements was adopted in 2005 and proposed for adoption by the member state and others. And both civil law and common law countries have special rules governing the suits for the judgment in rem, means judgment against the entire world. If the students are going to be there, they don't have to ask to them what is meant by judgment in rem or right in rem. With respect to the things which concern proprietary legal rights, unlike action for judgment of the personam, means particularly person here, with respect to the person like in contract, which concern personal legal rights, may seek money damages and injunctions to do or not to do an act, and in rem action seeks a judgment that produces effect of its own on legal relationship. Example includes the action to quietly to land for foreclose a mortgage of land by selling it, and to remove a party's interest and encumbers title to land. In common law, countries, family state actions, divorce, or the creation of the adoptive family child relationship have been linked to in rem action. For example, in divorce proceedings, particularly in the United States, the domicile of each spouse localizes the status and permits the courts as the domicile to assert divorce jurisdiction. Yes. At the same time, residence of varying length from several weeks to several months may take the place of or may presumably equal domicile for the divorce jurisdiction purpose. Of course, that depends upon the court discretion, whether at the time that is really will be want to be there or not. So we can consider that is stay over there is a domicile in a particular period or not. So that is, it can be done. So what I want to say is, here, to make it very much clear, at the same time, residence, I repeat, in the United States, the domicile of each spouse localize the status and permits the court as the domicile to exert divorce jurisdiction. At the same time, residence of varying length, some several weeks for the several months, may take place or any other presumably equal domicile for the divorce jurisdiction purposes. In contrast, civil law countries have not like the divorce jurisdiction to an rem proceedings. Yes, only the petition is before the court on the basis of the close relationship to the forum states. That is, a residence of the specified length of time. Central to the continued divergence of those jurisdictional approaches is the applicable law. A court following in rem approach to status matters will always apply its own law. In contrast, courts in civil law countries treat the action as a personam regarding a particular person, like in contract, and make a choice of law determination that focuses on the personal connecting factors such as the nationality or marital residence of the parties. Because civil law courts make choice of law decision with the reference to the particular parties and their case, jurisdictional standards can be more liberal in those countries than in the common law countries, where less restrictive standards would lead to the forum shopping. If the students are present to be there, I would have asking what is meant by forum shopping. Let us see what is the notification of parties. Who has to give the notification? For what purpose they have to give the notification? Fundamental fairness requires that the defendant receive a notice sufficient to afford him an opportunity to defend. In common law countries, the notice is effected with the service of process. Of course, terminology is different over there on the defendant. Similar procedure exists in the civil law countries. Services on the defendant in person is considered ideal, alternatively substituted services. Even by publication is a last resort when the whereabouts of the defendants are not known. Of course, local newspaper in the local language. International cases pose a special problem. Countries often cooperate bilaterally, either on the basis of the express agreements or as a matter of practice in aiding each other's court to effect service on the defendant. A very effective multilateral mechanism is the Hague Convention on the service abroad of judicial and extrajudicial documents in civil or commercial matters, in which some 50 countries, including the United States, China, Russia, and all the EU states, are party. It provides for a central authority in each member state that receives a service request from other convention states and execute from them according to their own national procedure. So this is the total coverage which I want to make it out. But a little bit I will highlight which is very much an important factor to me. Defining conflict of laws. So let's review again. Each country's legal system reflects its society values. As a result, national laws on the structure of the domestic judicial system vary considerably from country to country. Nevertheless, many kinds of legal situations or events, such as marriage, residence, estates, torts, and business transactions, often are not confined to a single country or even a single jurisdiction within the country. The courts of each involved country may claim jurisdiction over the matter, and the laws of each involved country may be applicable under certain circumstances. When such conflicts or differences exist, procedure procedure need to be in place to resolve them. The term conflict of laws sometimes also conflict or conflict of laws describe the body of law each country or a state that is designated to resolve the problem arising from the difference between the legal systems. Conflict of laws is a term used primarily in the United States of Canada and increasingly the United Kingdom. In most other countries and historically in the United Kingdom, the term private international law is used because in Tanzania, we also use the private international law because we follow the United Kingdom. There is a common law rules are concerned. The later term derives from the civil law distinction between the private and public law, whereby private law addresses the legal relationship among the individuals, corporations, and even the state in its relations with the individuals and corporations where it is not acting in a governmental capacity. For example, if the conclusion of the contracts, while the public law deals with the law governing such institutions as well as the later governmental exemplification, e.g., regulatory relations with the private parties, private international law that emphasizes the difference between the national legal systems. Along the term private international law may describe the subject matter may also mislead the suggestion there is an intentional body of rules to bridge the difference between the legal system. This is emphatically not the case. The term conflict of laws refers primarily to rules that are solely national in origin and are explicitly no part of the international law except insofar as countries have the concluded treaties concerning them. Conflict of laws must address three principal questions. I repeat, conflict of laws must address the three principal questions. The first, when a legal problem touches upon then on which country, it must be determined which court has jurisdiction to adjudicate the matter. That is the number one. In other words, we can say it's a jurisdiction. Second, once the court has jurisdiction, it must decide what law should apply the question before it. The question of law, which law could be applied over there, but in general, the forum will follow the procedural laws, but whereas come to the substantial law, depending upon the justice given to the parties, it will be decided whether the forum law or the special law from other country could be followed. The rule governing the court may direct it to apply its own law or call for the application of the law of another country. Third, assuming that the court ultimately renders a judgment in favor of the plaintiff, conflict law must address the enforcement of the judgment. That is the recognition and enforcement of the foreign judgment. That is the last point. In the event, then the defendant has insufficiently assets locally, recognition and enforcement of the judgment must be sought in a country where assets do exist. I think This much I would like to deal in this. Let us see which will be the important factor. Let me see. Common principles we did it. Okay, let us see the jurisdiction again. Let us throw on the light on the jurisdiction. As stated above, the first question is an international case potentially involving the conflict of laws problems is which court has a jurisdiction to adjudicate the matter, although the plaintiff decides where to use. The court in that location may not have jurisdiction, or they may have jurisdiction but be willing to exercise it for a reason for forum non-convenience, that is Latin inconvenient forum, as may happen in some common law countries. Rationality behind the choice of jurisdiction. What is the rationality would be there because choice of jurisdiction? There are several factors which affect the plaintiff decision of where the file a case. Once is convenient, for example, a plaintiff is likely to want to sue in a jurisdiction that is reasonably close to his home, particularly because witnesses evidence may be more readily available there. Legal questions also are important. A plaintiff may more likely to file a suit in a jurisdiction that afford him procedural and other advantages, and where the defendant has assets with which to satisfy the ultimate judgment. Example of likely procedure or the substantial advantages include the possibility of the jury determination of damages in tort cases, the availability of the punitive damages, the case of obtaining the territorial discovery of evidence commonly used in the United States. The possibility of suing on only a part of one's claim to determine the likelihood of success before committing a resource of a suit on the entire claim, some common practice in Germany. An advantage exploitation varies in the liability standards. However, the place of suit is not entirely up to the plaintiff. The chosen court must have power to retain the case jurisdiction to adjudicate. The jurisdictional grant will usually be defined by the statute. In addition, the exercise of the jurisdiction may also be limited as a check on the statutory grant or on the judicial exercise of it. By constitutional provisions or pervasive principles of law, the United States, this is the function of the due process course of the Fourth Amendment of the Constitution. Yes, the Fifth Amendment similarly limits the federal court in assessing the jurisdiction in cases not based on the state law. Now let us see that in addition, in common law countries, provision of law or the court decision-making practice may limit the exercise of jurisdiction to adjudicate for a number of reasons, including the need to prevent the local courts from becoming clogged with the litigation which they have no concern. Litigation between the foreigners concerning a claim that arose abroad, especially when it seems likely that court of the foreign state have chosen only as a means of gaining procedural or substantial law advantage not available to the plaintiff in his home country's court, so-called the forum shopping. Especially in the United States, courts may consider themselves to be the forum non-convenience in those circumstances and dismiss the action if it is favorable. The occurrence for Piper Aircraft versus Riono. I repeat, the occurrence of the Piper Aircraft versus Riono, a suit filed in the United States on behalf of the Scottish parties where the relatives are killed in an airplane crash. The flight originated in Scotland and were rescheduled to end there. The aircraft was owned by the British entity, a pilot was a Scottish, and all other relatives were Scottish. Only the defendant and the airplane manufacturer, that's a Piper, and the propeller manufacturer had a connection to the United States. Because of the plaintiff sought remedies that were not available, at least not to the extent desired under Scottish law, they decided to bring the suit in the United States, making the clear case as a forum shopping. The purpose of such a making would be there. We would have to make it the Scottish law would be there, then the problem of determining the compensation comes over there. But if the accident occurred in the United States, naturally the close connections of the transactions would be there. Perhaps that is the reason that instead of not following the Scottish law, then United States law could be followed in this case of the Piper aircraft versus Reno. American courts may dismiss the forum non-convenience when the exercise of jurisdiction could be unduly burdensome for the defendant. In many cases, dismissal protects the foreign defendants as much as it protects the local court from unfair burdens of foreign litigations. Courts likewise will not entertain actions concerning the title to real property located in another country, while their judgment would bind the parties before them. The power to deal with the property itself, with effect as against the potential claimant belongs solely to the country of the location in situs. Civil law countries generally don't dismiss the action for the reason for the forum non-convenience. The European Court of Justice has held expressly that the allocation of jurisdiction by the EU law, that the Brussels I regulations in binding on the national courts. As an exception, the Brussels II regulations permits the dismissal or the transfer of the forum non-convenience reason in child custody case. So that is the thing which I want to make it out. When each country determines the jurisdiction of its courts to entertain a civil lawsuit in federal countries or the unitary system with strong transition traditions of the regional and provincial jurisdiction, that is the United States, United Kingdom, Canada, and Switzerland, it becomes necessary to have the right rules to determine in which jurisdiction a civil suit can be brought. In some countries, like Germany, Austria, the central national law governs, wherein the constituent states may determine the jurisdiction, their courts themselves. The United States of the states court jurisdiction in a matter of state law in the United States, federal constitutional law, particularly in the Fourth Amendment, due process of equal protection, and the privilege and immunities clauses limit the exertion of the state court jurisdiction. Most countries allow the parties to agree the jurisdiction of the court. Consent may take the form of an express agreement in the initial business contract or the time the dispute arises. Alternatively, consent may be the result of the conduct. The plaintiff consent appears from the finding of the action. The defendant consent may be presumed when, rather than objecting the court's jurisdiction, the defendant confesses the judgment or appears and begins to litigate the controversy. And even when both the parties consent to the court's jurisdiction, the court in common law, yes, because this, I would like to end it by this time because we have did a lot.
Wabariki